Darin, is that you? Dr.
Hello.
Darin
Yes, I'm
Detwiler?
here. Can you hear me?
Yes, sir. Hello. Darin, it's good to talk to you.
Good to talk to you too. It's been a
Good
while.
to see you. Yeah, let me introduce you to my students at Lincoln Law School in Sacramento, and then why don't you introduce me? Fair enough?
Sounds great.
All right. Dr. Darin Detwiler is the Assistant Dean of Academic and Faculty Affairs at the Northeastern University's College of Professional Studies in Boston. That's where you are right now, right, Darin?
I am in Boston.
I'm in Los Angeles at the moment. He's also a assistant teaching professor of food policy who serves as the lead faculty for the college's MS in Regulatory Affairs of Food and Food Industry program, and is the recipient of the College of Professional Studies 2016 Excellence in Teaching Award. Welcome, sir.
Thank you very much. Thank you very much.
And
Let me go ahead and introduce you. Joe Rose, JD, he's an attorney and managing shareholder at Rose Law in California, specializing in labor and employment law. He's also a law professor at the Lincoln School of Law, or the Lincoln Law School, excuse me, in Sacramento, California. And I'm going to point out that you were formerly a firefighter and paramedic before you got into the law profession.
that is true. And I will point out that you formerly were operated a nuclear reactor on a naval submarine. Am I right?
I did, which has little to do with my job now, but unlike where I'm assuming that there's a lot of connection with what you did before and what you're doing now, I think there's one more connection we should bring up.
High school?
That's right. That's right. You're in Los Angeles area, I'm in Boston area, and yet we both went to high school together.
Yeah, I don't want to mention the year though.
Yeah, it was,
It's a few
it
decades.
was a few years back,
Right.
but
Well, I appreciate you suggesting. I think it's a fantastic idea for both of our online teaching opportunities for our students, for us to do this kind of reciprocal guest lecture where you're a guest lecturer in my class, I'm a guest lecturer in your class, and so we can talk about the intersection between labor and employment law, which is what I teach, and then food safety and public policy, and how those, interconnect, and the Venn diagram, if you will, of those subjects. I think that's a fantastic idea.
I'm really glad you like that. Personally, I'm teaching a course right now on law and economics, and we're focusing on the food industry. What are you teaching right now?
I'm teaching labor and employment law as an elective to
Okay.
law students. And so one of the things we're studying there in the class is not just the technical legal, meaning these are the statutes, these are the regulations, but what are the practical, everyday, real life impacts on people, not just the workforce, but on businesses and then the public at large. And I thought that one of the things that you and one of the features of your background that I think is really helpful for my students to know is your personal story and how you came into the food safety business. Would you be willing to share that?
I would. I mean, just enough to kind of make it relevant and pertinent here. As you mentioned, I was in the Navy, and right as I was getting out of the Navy, I had a son who was about a year and a half old at the time, and he became ill and died of a foodborne illness that was tied to a fast food restaurant on the West Coast. This was in Seattle at the time, Seattle, Washington, and this was 1993, and it ultimately tied back to some contaminated ground beef that was not cooked properly. But there was a situation where my family and my son, we did not eat the product. He got sick from a person-to-person exposure, but this was tied to the fact that there was a sick employee who was the assistant manager. She was sick with E. coli. Her son was sick with E. coli as well. She was sick with E. coli, but there weren't any kind of earned sick leave or family medical provisions, laws at the time. So she
What
went
year
back
was
to
that?
work. This was 1993.
Okay, 93. Okay. So that
So
would have
she
been right
went back.
around the time that Family Medical Leave Act was just coming into existence at the federal level. Go ahead.
Correct, correct.
Okay.
And there were some variations from state to state at that time pertaining
Okay.
to that.
Okay.
But she ultimately went back to work because she had to, or she would have lost her job, because she was not able to take that kind of earned sick leave or the family medical sick leave. And so um, she and her son ended up spreading it to other people, including my
Mm.
son, because my son and this woman's son were both in daycare together. And in the case of my son, within 30 days, he'd gone from showing symptoms to dying because of this public health event where a foodborne outbreak not only sent 750 some odd people to the hospital, but it involved the deaths of 4 young children. And you don't want to find yourself in a situation where you learn about something like this when a loved one is on their deathbed. And I turned my attention to how can I help this, looking at, and I needed to learn about not only regulatory compliance and science, but also about the law. And so in my class, when I'm teaching about law and economics, I have to go beyond the law and the numbers to look at the idea of the kind of human needs, true burden of disease, that public health impact as well.
Got you. So this is a real, I mean, that's a tragic story. I know it's been many years, but it never gets easier. I'm sure this is a very real impact, obviously, of an employee who is, I'm just looking now at my notes. I see the Family Medical Leave Act. President Clinton was in office at the time. It was enacted. He signed it February 5th, 1993. So this was just coming into
Right.
existence. What we
Well, and
now
at the time, this was one of those arguments we were making. Look, if this had been in place earlier, this could have been prevented. So don't think about this as a cost or as a luxury for those employees. There's a direct connection that can be made right here, right now, with what was going on in early 1993
Sure.
between not having the earned sick time or the family medical
Yeah.
in place, and that impact on public health. So it became a bit of that policy window opportunity in terms of you guys are talking about this in the halls of Congress, and in the hallways and in the congressional meeting rooms. Here is one more very ongoing example of why we need to talk about this.
Yeah. So that's interesting. So what may be helpful for your students to know? Because a couple different things. One, most people think when they're talking about employment law or labor law that you're really talking only about the relationship between the employer and the employee, right? And so this is sometimes an ideological debate because the more you give the employees, some people view that as more of a takeaway from the business and vice versa, profitability and so forth, right? So, and this is one argument, you see it kind of in an analogous way on the minimum wage debate. So raising the minimum wage versus keeping it static. But the interesting, I think what might be interesting for your students to know is paid sick leave and Family Medical Leave Act are two separate concepts. They're related. The FMLA, Family Medical Leave Act, which was enacted, as I said, in 1993, that's job protection for being away from work, meaning that if you need to take some time off, you can take up to 12 weeks of job protected leave, paid or unpaid, with protection, as long as you have a qualifying illness or injury. And that doesn't mean necessarily that you get paid under
Correct.
that law. So it's one thing to say, okay, I get job protection. My boss cannot fire me or retaliate because I request leave because I need it, because I have, in the circumstance you're describing, I have an old child with E. coli. But it still doesn't address the wage replacement piece. So even where an employee is not afraid of losing their job because they have a fair and reasonable boss, and maybe the boss wouldn't fire them anyway, there's still the practical reality is that if I miss these days of work, I'm not going to be able to make ends meet at the end of the month because I don't have the wages to make that happen. And so that's where the paid sick leave comes in.
Sure.
That, Darin, is so recent in California. it was only 2015 when we started here in our state requiring state employers of a certain size to provide paid sick leave of at least 3 days. That's 8 hours for a total of 24 hours per year. That's the limit. Now, that's also, we're kind of, we have a recent experience with the COVID-19 outbreak and the coronavirus emergency legislation enacted by the U.S. Congress to provide additional sick leave benefits to people who were specifically suffering from the impacts of that pandemic. But again, I think that we have a long way to go on that. But the important thing is, in your circumstance, I'm curious to know how you found that if those factors played a role in the employee's decision to go to work with E. coli exposure.
Definitely. That was a fear. She literally came out and said that if she didn't go to work, she was going to lose her job. And if she lost her job, what was she going to do? Now, you brought up 2015 in California, and my first thought was about the Chipotle outbreaks and how in Simi Valley, California, kind of about an hour-ish near north of Los Angeles, there was an outbreak of norovirus where they had 17 employees at this Chipotle restaurant who were sick, and the state and county health laws were that you couldn't work if you had, norovirus, and that they were allowed to go on sick leave. But they weren't, if they hadn't been working long enough, like you said, some were paid because they had earned that, and some had not been there long enough, so they did not earn that, so they were not allowed to go to work, and they were not being paid, and many of them, well, technically they were only banned from working at Chipotle. They would go to other restaurants, like some other restaurant in town, and continue with that job because they still had to pay their bills. So it doesn't take away from that, and I think one more level of consideration is it's easy to say, all employers, all employees. Well, you have some like you said, there's difference of employers in terms of how many employees they have. Is
Right.
it a private company? Is it a publicly owned company? Is it a government entity? But also there's the religious beliefs of the employers, like we saw with Hobby Lobby and some other companies, where it was about the religious beliefs of the owners. On the other end of that scale or matrix, if you will, we can look at employees. Not all employees are adults, right? Some employees are children. They are minors, and
Right.
there was a recent case right here in Boston, Massachusetts, where Chipotle, again, same restaurant, was fined $1.37 million for violating 4 different violations that took place from 2016 to 2019. They violated child labor laws by not giving their employees earned sick time, by not following records laws, failing to pay wages on time, failing to inform their minor or child laborers, employees, of their rights under these federal laws.
Wow.
So, it's amazing how you can talk about the same company in two completely different situations, and you can see that whether we're talking about employment law, labor law, earned sick or family medical laws, there are many legal and economic considerations to take to take awareness of, both as an employer and as an employee.
Right. So it's interesting you bring up child labor. The background on that, as you probably know, is during the Industrial Revolution and the age of the robber barons and so forth, child labor was very common, and it was really expected. The kids go to work, and they work all the time, and they work long hours and days, and so does dad, and they work 6-7 days a week. And it wasn't until the New Deal and that legislation where we had what became known as the Fair Labor Standards Act, or FLSA, not to be confused with the FMLA. Lots of acronyms in my world, and I'm sure in yours as well. But
Right.
so that was enacted during the New Deal. basically regulated and outlawed to a great extent to child labor, and then established a federal minimum wage, which didn't even exist prior to that time. If you can imagine that, the employer could pay you any amount of money that you would be willing to accept. And then, of course, when you look at the bargaining power of workers versus employers, who has the superior leverage in that scenario, right? If that's what the job pays, and if you want a job, that's what you're going to take. So federal minimum wage came in. Fair Labor Standards Act regulated and outlawed to some extent the child labor. And then there's been state, laws around that. In California, for example, minors 14 to 15 years of age can work up to 3 hours on a school day. So that's still a full 8 hours probably, or at least 6 hours of school plus travel, and then an additional 3 hours of work. So that's still a full day, 18 hours per week, and 8 hours on a non-school day between 7 a.m. and 7 p.m. when school is in session. So there was some protection there for kids, for young adults or children really, or teens rather. But that's what we're dealing with in California. What do you think about that? Do you think that has an impact on public safety and health?
Well, definitely, the safety of the employee, the child. I mean, when you're talking about the New Deal laws, you're talking about the time period of the great stock market crash and the Dust Bowl. You're also talking about a time where we were shifting from a mostly agricultural and rural, where we were living at the time, to industrialized and urban settings. And a lot of kids, they were working. It's, I guess, great for the family because there was an extra source of income. But it was great for all these, big industrial machine companies because they were smaller. They could fit into tight places. Their arms could reach into places that adult arms could reach into. And this is where a lot of the injury was coming into play. You have a lot of situations now where if you start looking at technology and chemicals and biotechnology, now you look at children in terms of understanding internet safety or understanding the nuances of chemicals. Well, how can they understand it if they don't have a high school education, or if they don't have the maturity and wisdom that comes with being an adult to work in those scenarios? Today, I think that though we can clearly see almost 100 years later, 90 to 100 years later, we have companies that will violate child labor laws.
Right.
We look at other similar laws as well, not only just the idea of the earned sick time and the family medical leave, but what about the laws related to employee labor, labor force in our prisons, and even outsourcing to third world countries? Or to other countries, to less developed nations, where we're depending on those workforces. The number one reason why we looked at child labor, we look at prison labor, we look at outsourcing to other countries for labor is economics. It costs less to employ them, to pay them salaries, to pay them benefits than it would if we were to hire an adult American, male or female, to do the same job. It comes back to purely that balance between where can we find the loophole or that leniency between what the law has in terms of provisions for and against certain aspects of labor, and where economics is going to tell us here's our best return on investment.
Exactly. No, it is really a balance, because for my employer clients, when you start to drive up labor cost in the extreme, then you start to really push people to the brink of an inability to continue to operate. This is especially true for my restaurant clients. I represent a lot of franchise owners and restaurateurs, and so they have a workforce that they tend to rely heavily on their tips in addition to the hourly rate, which is typically at or very slightly above minimum wage. And these are the folks, as you say, that I think are really vulnerable to the scenario that happened with your son, who ultimately ate food that had E. coli in it. And is that right?
Well, he got sick. It was a person to person, like passing the virus from person to person. But sorry, my phone was going off. Um,
Okay.
uh, the idea there being is that sometimes there's the costs that we don't think about. Again, there's the public health cost, the medical bills, the cost on the family, the emotional cost. But if you think about the idea that um, sure, there are companies that might say it will cost us a little bit more to pay employees when they're sick. Yes, that is true, but it'll cost you a lot more if you're
Mm.
sued by 700 people because you contaminated 700 consumers. And yes, a company could say it'll cost us more to follow the child labor laws, but as we saw earlier this year with Chipotle, it would not have cost them $1.37 million more to have been in
Right.
compliance. And one thing that we see as a consistent economic evaluation is when it comes to that balance between law and economics, there's the cost of compliance and cost of following the law.
Right.
But on average, it costs 17 times more if you're not in compliance or if you're not following the law. When you look at legal costs, out of court settlements, court fees, fees and fines, typically, I mean, there's going to be a range, but the average right now is looking at 17 times more expensive to be out of compliance and not following the law than it actually costs to just follow the law and be in compliance.
I'm just curious, there's obviously a federal regulatory scheme and a statutory scheme for protecting food, right? I mean,
Right.
in terms of preparation, in terms of in the stream of commerce, what are there big penalties if you're caught violating the law in that regard?
So that is a
Not storing your
whole,
meat at the adequate temperature or
sure,
something like
that is a topic for a whole other lecture, but here's the reality of it.
that?
There have been fines and fees that have been paid over time, but those are considered the cost of doing business.
Yeah,
And up until just a few years ago, the 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 worst anyone had ever seen is probation. There was a case where someone was sentenced to 3 months in prison for killing some people. But then came this case called the Peanut Corporation of America, where not only were the CEO and his top executives, they had 97 federal criminal charges filed. They were found guilty of all but one, and the CEO, again, previously the worst that ever happened was 3 months in jail. The CEO of this company was sentenced to 28 years in prison. This was in
wow.
2015, and that sent this shockwave not only through the courtroom, and I was in the courtroom at that exact moment in
No
in
kidding.
Albany, Georgia. I was working with the prosecution team on that, but it sent a shockwave through the food industry
Were you
and
an
through
expert in the case?
industry. Yeah, working with the victims who were supporting the prosecution team to make sure that the full understanding of their impact, because ultimately they were found guilty on criminal charges like fraud, obstruction of justice,
Wow.
wire fraud, so many different criminal counts. They were not found. They weren't charged on, obviously, if you're not charged, you can't be found guilty on any
Yeah.
tort laws. They were all those
Yeah, which is
97
civil.
charges were purely right, exactly. So they still were allowed to bring in, though, the voices of the victims and the victims' families, so that the understanding of the true burden of disease, beyond the law, beyond economics, was understood in the courtroom
Yeah.
when that decision was being made. That it's not going to be simply 3 months and a fine. We're talking 28 years, which for a person, the CEO was 62. You're talking about a life sentence at that point.
So the
Um,
discovery in this circumstance, Peanut Corporation of America, that was a discovery based on people getting ill and dying from the food that wasn't properly maintained. Is that essentially it?
Correct. Ultimately, there were over 3,900 different types of products that had peanuts or peanut dust or peanut flour in them, including dog food, ice cream, candy, cake mixes, so many different kinds of foods. Hundreds of companies were impacted. This was the largest recall. We're talking evaluated at over $4 billion of an
Wow.
economic impact of a recall. And at the same time, the company was lying to the Department of Justice because it was the FDA that was investigating, but it had to be the Department of Justice that was prosecuting.
Right.
And in that whole process, there was the obstruction of justice and the lying to the investigators about what they were doing and where these things were taking place. And there were so many other elements to it that ultimately this became this kind of landmark court decision in terms of the accountability now of industry in terms of
Mhm.
all these different laws coming into place. Yes, this had nothing to do with child labor laws or earned medical leave, but the idea of companies breaking law, companies breaking the law in the past, these large companies never really being held accountable for much more than just paying a fine or a fee, and this being the cost of doing business. In this case, we now see that you can be held, and this goes back to the responsible corporate officer doctrine of 1975, Park v. U.S., in which
Wow.
an executive can be held personally and strictly liable for their failure to take actions knowing that it was going to cause public harm.
Two things come to mind in the employment realm based on what you're describing immediately, and I'm sure there are more, but just my immediate thinking is one, imagine being held criminally responsible for the manner in which you perform your job duties. That's huge,
Mm-hmm.
right? So that's significant. Also, imagine being the employee inside that knows these laws are being violated. You want to report them. You want to blow the whistle on the illegality so that people's lives can be saved. But then you've got these counter motivations. You don't want to lose your job. You're afraid you might get fired. If the company goes bankrupt, where are you going to go to work? Are you going to be blackballed or be on or blacklisted because you were the one that blew the whistle on Peanut Corporation of America? It sounds like in this case it was because of they probably had cooperating witnesses at some point. But
Yeah, but
there are laws.
there was a whistleblower,
Was there?
and it was this man whose name there's documentaries and articles out there. His name's Kenneth Kendrick. He was the
Okay.
whistleblower that helped the Department of Justice find where the actual problems were, and he has not been able to hold a job ever since. It's been at least 8 years that he's never been able to get a job as a result of what he thought was doing the right thing and protecting others.
Kenneth Kendrick hasn't been able to find a job in the industry.
In any industry, quite honestly, because the guy who was a whistleblower for the Peanut Corporation of America case, essentially he worked with the prosecution, he worked with the Department of Justice, and he has not been able to get a job ever since because, employers are worried that he might, spill the beans on failures in that job, in that facility, that firm.
Yeah.
So it's tough, just like an employee who is sick doesn't necessarily want to stay home because they'll lose their job. Employees who think of doing the right thing is blowing the whistle. They start thinking twice about it because they might, just as well, lose their job for that action.
It's true, and my experience in the practice of law and representing some whistleblowers has been most often the whistleblowers are industry experts. They've been in this industry for a long time. They
Yeah.
build up knowledge, skills, abilities that are very industry specific, and then there's a
Yes.
limited universe of potential employers, and they're all connected, right? So it makes it even that much more difficult because now you're contemplating that, say, after 10, 15, 20 years of being in the food business, you now have to change careers to a different industry. The law
Right.
does have protections for failure to hire, protections
But
for,
right, but whistleblower laws are federal level. Whistleblower laws don't apply to the private company kind of a sector.
no, there's there's federal whistle. There's a whole array. It depends on who your employer is and what
Correct.
you're blowing
Correct.
the whistle on. But there's also state level, that vary, state level whistleblower
Right.
laws. But the practical reality in the world is, as you probably know, Darin, is you have to prove that the reason you were let go or the reason that you weren't hired was
True.
motivated by you blowing the whistle, and you have the
True.
burden of proof as the whistleblower. That's not always possible. It's not. Employers generally don't say, "Hey, we're firing you because," or "We're not hiring you because you blew the whistle on illegality back when you worked at, Peanut Company or the Peanut Corporation of America."
Right. Right.
So then it's a circumstantial case. You've got to dig into the emails and dig into the timing and what nexus factors exist between the adverse action, that being the failure to hire, and the protected conduct, that being the
Sure.
blowing of the whistle. So,
Sure.
well, this
I
has been
can't
an
believe
amazing. Go ahead.
I was going to say, I can't believe we've already been talking for 30 minutes,
Oh,
and
wow. Yeah.
um, there's so much more. There's so many more examples and nuances we could talk about. But I think that, we wanted to kind of keep it to half an hour here. I think in closing, wrapping this up, there's so many nuances and differences that both the employer and an employee need to take into consideration. This is why we have, for instance, you go into your place of employment and you'll see posted laws and regulations, employee rules and information about sick leave time and things of those nature, because most people don't know about these things, and if you don't know, you don't ask, or you don't inquire about what are my rights, what are my resources for this. This is why we actually have laws that say that employers have to post some of this information. And I think that in your line of work, more so than I work with students, but you work with employees and employers who might know about these laws, but don't know enough such that they can make the best decision, the best educated decision without connecting with a lawyer.
No, that's why employment lawyers exist, right? And so even as a practicing employment lawyer with 20 years of experience in this field, it's constantly evolving. I'm constantly staying abreast. As a recent example, this coronavirus legislation, there's emergency legislation in the recent history of the country where that affect employers and employees. Yeah, it has been a great time talking with you, Darin. I really hope we can do this again. I think it would be valuable. Maybe we can find some other subjects that would be of mutual interest to your students and mine. Let's do it again.
That sounds great. Well, to your students and to my students, thank you very much.
Likewise, to all of Dr. Detwiler's students, it was a pleasure being in your classroom, virtual classroom. Thank you.
Thank you.